Good afternoon, everyone. Ladies and gentlemen, a very warm welcome to our joint Magnuson Legal 500 webinar on Nordic Baltic FDI rules and regime and screening processes. My name is Sam Jalai. I'm really honored and privileged to be moderating this session today. I'm an equity partner and chairman of Magnuson Denmark and co-heading corporate M&A with Nikolai and heading capital markets. For those of you initially who haven't really made acquaintance with Magnuson Law Firm, just briefly, Magnuson Law Firm is a Nordic Baltic full service law firm. We are approximately 200 plus lawyers scattered in our offices in Denmark, Sweden, Finland, Latvia, Estonia, Lithuania, and Russia. We have a panel of distinguished experts, FDI experts lined up for you today. We have my esteemed colleagues from Magnuson offices who will be introducing themselves later. We are also joined by a very esteemed law firm in Norway, Håkon Gisli, represented by Simon Klepsland. And just to give you also a little bit flavor of the business side and commercial side of it all, we also have the legal counsel of Huawei, Mr. Thomas Latola, present with us today. And also the general counsel of Soma Equity, private equity fund, Mr. Martin Surlund, who is also part of the panel today. Thank you guys for being part of this session. The agenda of today is that we will be diving into the challenges posed by the FDI screening and rules and processes, not only in the Nordics and Baltics, but the whole new FDI screening regime, which has popped up all over Europe, has added a little bit of complexity to the cross-border M&A deals and also investments across the region. So the team of panelists today, they will touch upon both legal, commercial, and practical side of the FDI rules and regulations and the whole screening processes. We will also dive into, in terms of deal certainty, how will this FDI process and the whole screening process, rules and regime have an impact on deal certainty, deal value? Will it bump up and increase transaction costs? What is critical sector, viewed as critical sector, what's not critical? It's still, some of the countries have quite a broad definition. So the team of experts and panels will elaborate a little bit on how they see it in terms of legal and practical and commercial business side of it all. It's still, as many of you know, early days. Jury is still out. We still don't know how the various business authorities will approach this new regime and rules. There's a very limited and few precedent as well. We have some few in Norway as well. I'm sure Simon will enlighten everybody about the case they had in Norway. And what about the authorities? Have they enough resources and manpower to have all the pre-screening processes going through all the 26 authorities in the EU and the Commission? How should you go about it? In terms of practical information, practicalities during the webinar today, I kindly ask you to stay muted during the presentations and present your questions in the chat room, and they will be addressed accordingly during the Q&A session. Each country today will make a brief 6 to 7 minute presentation and introduction of the FDI rules and screening processes in each country. In between, we'll have Thomas and Martin to enlighten us a little bit about the business side of it all, the business commercial perspective of the whole FDI regime and how they view it in terms of business. And having said that, without further ado, we basically were most interested in have you guys engage. We want you to, we want to have interaction and dialogue. So please, as an audience, jump in with your questions, and we'd be happy to address them at the Q&A session. So without further ado, Janos, I'll turn to you as the first speaker. The floor is yours, and please introduce yourself and present about the FDI rules in the Baltics. Thank you.
Hi, my name is Janos Mägi, and I'm head of Magnuson's office in Tallinn, Estonia. And in this context, I'm also country rapporteur for Estonia in SELIS Institute, which is designated institute for FDI screening. Firstly, I would like to point out that Baltics are different. They're different from the Nordics, and they're also different as compared to each other. The legal systems have developed in different ways, and I'm only qualified to comment on Estonia. There will be a short overview about Latvia and Lithuania also. Kudos to my colleagues from Riga and Vilnius Magnusson offices, but my ability to comment on the details in these jurisdictions is clearly limited. So how are the Baltics different from the Nordics regarding the general FDI situation? Although we both have high levels of FDI relative to GDP, majority of FDI in the Baltics tends to be from EU and other European countries. Nordics have much more varied composition of foreign investors. So if we look at the historic context, then 30 years ago, there was still full control of any foreign investment. Basically, everything in the Baltics with the foreign element needed to be government approved. And even a couple of years before that, this approval came from Moscow. So these days, those jurisdictions are among the least restrictive ones in OECD. If we can take a look at the chart of the OECD foreign investment regulation, then we can see that Estonia and Lithuania and Finland are quite, and also Latvia among the lowest restrictive ones. Still, historically, the national security and public order concern in the Baltics has been more related to Russia rather than Chinese investments. And although it has changed slightly during last years. And just to give a brief comment on this, the Baltic states, despite publicly declared interest in deep economic cooperation with China, have just minor economic dependency on Beijing. The trade volumes, transit, and FDI flows are minimal. And at the same time, China can't really implement the patterns of its economic expansion in the Baltic states because we are comparatively in good financial situation, and there is a presence of vast EU funding for the strategic projects. And it has been particularly visible in the cases of 5G disputes and possible Chinese investments into the transportation infrastructure. If we Klaipėda port in Lithuania, Rail Baltic, and hypothetical Tallinn-Helsinki tunnel, just to mention a few projects which were of concern. Again, if we look historically, the regulation and legislative focus in the Baltics has been strongly towards real estate, land, rather than emerging technologies and industrial policies. And maybe one more thing which is relevant is, at least in Estonia, the close cousin of FDI screening, the prudential ownership control in financial sector, has been working well. Moving now specifically on to FDI screening. At least from Estonian point of view, no one could argue that when in March 2019, the EU screening regulation was adopted, it was a delicate, coordinating and not harmonizing instrument, and it was very welcome. However, as you know, pandemic changed the game everywhere. And if we look at the EU guidance to member states in March 2020, it was clearly a strong endorsement of the necessity for national FDI screening instruments, and also it redefined the definition of national security and public order, enhancing those categories to health sector and emerging technologies. Considering the present low level of restrictions in the Baltics and the importance of unhindered flow of foreign investment into our booming startup ecosystem, it is still hard to predict that there is a strong appetite towards more burdensome environment for foreign investors. However, we are members of the EU, and it is difficult to fight the general trend. Although the host countries have the final say, member states and the European Commission may issue comments and opinions on transactions involving FDI in other member states, and the host member state must give these comments and opinions due consideration. If we move forward to specific regulations, then you can notice that Latvia and Lithuania have notified the Commission about their instruments, and Estonia has not, because it does not have one. It does not mean that we are not participating in consultations under the regulation, but there is no specific regulation in Estonia. So if we move forward specifically to Estonia, then you can see that there has been a progress. There is a mistake. The legislative proposal was in June 2020. There has been an impact study, and now there is kind of every day, every week, every month, there should be a draft law published. But it's still very hard to predict what the final version will look like, because at this point there has not been political input, and we don't know how this works out. So the best source is published impact study, and if we go quickly through this, then if we take a systematic look, so I think it's slide 8 or slide, yeah, if you can. So it makes quite clear distinction between investors originating from EU and outside EU, and there is no discrimination between the non-EU countries. Thresholds and other means of obtaining control, this is maybe too early to predict, but impact study has been studying the influence of a 10% threshold. And maybe the best indicator what will happen is the scope of the FDI regulation. And here I can say that at least the impact study is quite proposes quite narrow scope. So it's critical service providers, defense industry investments, media service providers, and it also reholds the real estate investments restrictions which have been in place for some time, but they are now quite obsolete. And maybe last but not least, the review process. There will be ex-ante proceedings with a special commission, and that would maybe be more similar to strategic and dual-use goods commission rather than merger control kind of permanent body. There is possibility to have mitigation measures during consultations negotiated. At this stage, there are no gun jumping provisions like in some other jurisdictions, and no criminal penalties are on the table. Judicial review of the negative decisions is carried out by administrative courts. The problematic situation is, of course, if there is an input from the security and intelligence institutions or information obtained by consultation with other member states and EU Commission, to which the target or investor then might not have access. So if we move on to Latvia and Lithuania, then Latvia and Lithuania already have well-established regulations on FDI screening. which are still clearly more focused on critical infrastructure than sensitive technologies or health sector concerns. Latvian mechanism provides for ex-ante procedure. The Latvian cabinet may decide to restrict the transaction if it results in influence, endangering or potentially endangering national security in commercial company of significance to national security. The foreign investor must apply to Ministry of Economics before carrying out the transaction. And also Lithuanian Act subjects certain transactions to mandatory ex-ante screening and provides the possibility, if we go to Lithuania now, and provides the possibility for also for ex post facto screening on a discretionary basis. The ex post screening can be launched by the government or different other public institutions. Yeah, that was Lithuania. If we can also have some more specific information. I won't go very deep into this, maybe just quickly some final comments. When we're discussing the Estonian regulation or proposed regulation, then it would be quite interesting, as the devil is in details, for practicing lawyers, how is passing of the company's specific information before the transaction has been cleared, how this is regulated, because this could be really a challenge to M&A and due diligence procedures, and would maybe lead to, again, to need for clean team or clean data room arrangements, and it would be quite interesting how those work out. And maybe also to end my comments with a very optimistic comment is that you shouldn't be thinking that this is the end. This is just the start. There are commission white paper on subsidies. We are going to screen the sustainability of supply chain. So it seems that international business will not be the same as it used to be in coming years. Thank you, Sam.
Thank you very much, Janis. Thank you for enlightening us on the whole Baltic landscape in terms of FDI rules and regime and screening processes. You mentioned a couple of important items, in terms of infrastructure, and I will dive into that. Bringing in you guys, Martin and Thomas, just to add a little bit flavor to this webinar, besides us lawyers and lawyering up this webinar. Starting off with you, Martin, I'd like to ask you, as a private equity investor, how big of an issue and risk do you see actually this FDI regime introduced not only in the Nordics and Baltics, but also across the entire Europe? How do you view it as a private equity investor?
Thank you. I think it's kind of famous last words, but currently and up until now, we haven't really viewed them as a major problem or a major obstacle, more kind of a process matter, something that needs to be naturally assessed in relation to each and every deal, and also kind of handled accordingly, similar to kind of merger filings, etc. But I mean, I think the more important point, because we have obviously no chance of being subject matter experts here, from my perspective. So the more important point, I guess, is the general view and the general sort of trend, which makes everything much more difficult. And I guess we're not there now, but you can kind of see the direction, and it's not only in Europe, but also in the US and also in some Asian countries, and it kind of naturally it makes things more difficult. And I guess that, you know, if it would become a particular issue, that would absolutely be something we considered before engaging fully in a transaction. Because, you know, once we've done that, you know, we have obviously started to incur significant costs.
So that in terms of, thank you, Martin. So in terms of deal certainty and deal value, you obviously see that there might be somewhat of a risk impacting both deal certainty and deal value, because, you know, there's got to be a process, obviously.
Yeah, no, definitely. And I think that, I mean, again, I mean, it kind of depends if you're on the sell side or the buy side. I guess from our perspective, the main headaches would actually arise when we're on the sell side, because then you will always have, I mean, I wouldn't kind of, it's really hard to kind of put a number on this, especially now, since we don't really know what we're up against. But I mean, obviously, if we're looking at two different buyers, and we kind of, our desktop analysis is that one has a more straightforward path to closing. I mean, that's an obvious pro, of course, and we like to, you know, keep the signing closing period as short as possible for obvious reasons. But I mean, you know, nobody knows really what's going to happen between signing and closing with kind of the macro world and, you know, the world in general. So yeah, we really like to keep those timelines as short as possible. And I guess then you, I mean, then you would probably see, I don't know if you would see a real implication on value, but at least you would, you know, you often end up with two bidders more or less on the same number, right? And then it would be a great advantage for the one with a clearer goal to closing.
Yeah. Thank you, Martin. Thomas, bringing you in, my friend, into this discussion from the business side of it all again. You know, I know BBC had throughout the years a program called Straight Talk, and issuing a straight question to you, Thomas. As a legal counsel with WOWI, you know, responsible for the Baltics and Finland, do you see any risk of this, you know, mechanism, the whole FDI regime, be used or misused or abused, if you want, as a, you know, trade policy or trade war tool? Yet you have, you know, for instance, infrastructure. You know, Janos was talking about infrastructure, how important that is in terms of scope and wide scope everybody is talking about. Do you see any risk that this will be used as a tool? I mean, infrastructure be categorized as a part of national security and public order, and prolonging and bringing, you know, additional complexity to the deals?
Yeah, thank you, Sam. It's a very good question. I think there's definitely some risk when you come to regulating all sorts of business that you cross into trade policy. What makes this very tricky is that, as we all know, each member state is responsible for its own national security, and it's the exclusive competency of each member state. And in the Baltic states, for historical reasons, obviously the national security is a very important topic, and like Janos mentioned, this is what drives a lot of regulations rather than industrial policy. But of course, we've all been following these China-US trade war news that began during the Trump administration in the White House. So this obviously begs the question that where are some of these concerns emerging from? Now, while each member state is responsible for and has the sole competency on national security, and this is usually from the regulator's point of view, they might think that this is national security, so this is our own topic. EU law perhaps is not so relevant, but that is actually not the case. There's quite much European Court of Justice cases where there's some overlap between the EU law and national security, and then obviously each EU member state is a member of WTO, the World Trade Organization, through EU, and for that reason the trade policy obviously has to be exclusive competency of the European Union, and each member states cannot have their own trade policy. So this is a very tricky area if one member state has some sort of like trade barrier, for example, or some kind of like a national security screening mechanism that turns out to be a trade barrier, this would be potentially whole EU's WTO violation, and that's obviously very tricky area.
Janos touched upon the whole Baltic. I know you work very, you're responsible for Baltics, and you work very closely, and you're very accustomed to the rules and regulations there. And as I understand, some of the Baltic governments have introduced these criteria in terms of providers of equipment and suppliers. And how transparent do you find those criteria in your book? Is it something that is clear cut and straightforward, and how do you see them?
Well, like you mentioned in your opening remarks, we are very much early days here. I must say that even though each Baltic state is very different, like Janos mentioned, and the regulations and the sort of legal frameworks have their own unique characters in every country, and also the angles they approach these questions are a little bit different everywhere. I think that what is common is that the first drafts have been quite non-transparent, and the criteria has been quite vague, or there has been no meaningful criteria. But I would say that through extensive public consultation, because obviously the industry has been very keen to have clear rules, things are moving in the right way. And with right way, I mean that there's been increase in transparency, increased understanding from the regulator side what needs to be taken into consideration. But still, I would say that overall some work needs to be done to make sure that we have clear rules in place. And here one positive element that we are seeing is that instead of coming up with their own definitions, for example, when you're regulating some technology or something very technical, you don't maybe want to come up with your own termination that nobody understands. This has been happening in some European countries, but now we are seeing more that, for example, in the telecommunications field, that countries are following 3GPP international definitions for different, which are standardized terms and easy to understand for the industry participants.
Okay, excellent, Thomas. Thank you, Martin and Thomas. We'll be reverting to you guys and getting back to you to get further input. Now moving to next country presentation. It's our dear friend Simon. Simon, please, from Hoven Gisli, please introduce yourself and kindly present to us the whole Norwegian landscape in terms of the FDI and how you guys have been experiencing it.
Thank you, Sam. So my name is Simon Klestrand. I'm a partner at Hoven Law Firm in Oslo, where I head the EU and competition team. So first of all, I think I should mention on the top that the EU screening regulation isn't applicable in Norway. So Norway is not part of the cooperation mechanism in the regulation. So that means that Norway, unlike the Baltics, and also unlike the other Nordic countries, has no formal system of information sharing with EU member states regarding transactions under review. So the issue of investment review sort of exploded in Norway earlier this year with this case, the Rolls-Royce case, or the Bergen Engines case. So it was Rolls-Royce planning to divest a Norwegian business called Bergen Engines, which makes diesel motors, mainly for ships. And they provide some maintenance and repair services on those motors or engines. So not really very high tech, but there were two issues with this transaction. So first of all, Bergen Engines was doing maintenance and repair on a few Navy ships. And secondly, the buyer was controlled by some Russian oligarchs. So maybe not very high tech, but definitely a type of transaction that you could expect the government to wish to look into. So Norway does have a mandatory FDI screening regime, but this transaction fell outside of those rules, and I will explain why very soon. So Rolls-Royce did not have filing obligations, but they very diligently contacted the Ministry of Foreign Affairs informally in advance, provided details on the transaction, on the buyer, and they essentially got an informal green light to go ahead with the sale. And then time passes and there is critical media attention, there's pressure from the political opposition parties, and suddenly the government decides to look further into the transaction. So at this point, the government started looking into whether they could block the sale, how they could block the sale. And as I mentioned, the sale fell outside of the formal screening regime. So why was that? Let's move on to the next slide. So Norway's screening regime is unusual in that it's entity specific. So it's limited to a number of individual companies and not to entire industries or sectors or products. So even acquisitions of company which makes weapons or which make high-tech products for military use, they don't automatically trigger a mandatory FDI filing. So if the target business hasn't received a decision saying that from now on, this company is subject to the National Security Act, then there's no filing obligation. So only if a company has received an individual letter to the company stating that it's now subject to the act, only then will we have a mandatory filing obligation in Norway. And there's an important point there because there's no publicly available list of all companies that have been made subject to the act. So as a buyer in a due diligence process, you essentially have to ask the buyer, are you among the few chosen ones who have been who have received a decision to the effect that you are covered by the act? So this means that the mandatory screening system in Norway covers very few companies and transactions. And the sale of Bergen Engines didn't trigger a filing since the company had not been made subject to the act. However, the jurisdiction to review foreign investment isn't limited to transactions which trigger a mandatory filing because the government has a general and essentially unlimited power to intervene. And let's move on to the next slide. So we have in Norway, Section 2.5 of the National Security Act, which is a legal power to block any acquisition which could be a threat to national security. And interestingly, this provision is not specifically targeting acquisition, so it applies to anything. The same provision here, which can be used against foreign direct investments, has also been used to block a pedestrian bridge from being built too close to the offices of Norway's police security service. So a quite broad scope for an investment review provision, I think. So the problem with this clause, with this legal basis, is that there are no safe havens. So the power for the government to intervene is not limited to targets in specific sectors. It's not limited to non-EU buyers, and there's no ownership threshold. So in practice, the parties must always make a concrete case-by-case assessment of the potential for any national security concerns. So what we have here essentially is general power for the authorities in Norway to call in a transaction, but without a procedure for requesting notification and without a procedure for submitting voluntary notifications. So in some transactions, it may be advisable to informally contact the authorities in advance. But since there's no formal process for it, the government will always continue to have, if they want to, the power to intervene at a later stage, even if you have an informal confirmation that there are no concerns. So in the Bergen Engines case, this is a provision which was used to block a transaction in Norway for the very first time. Let's move on to the next slide. So we've summarized the government's grounds for blocking the sale there, and I think it's fair to say that this is rooted in kind of traditional national security concerns. So this is not really about protecting strategic industries or about any industrial policy. objectives. So the buyer wasn't only from outside the EU, but it was from Russia, which of course isn't a very close ally of Norway. So based on this case alone, it's difficult, I think, to predict whether the government could go further in future cases beyond traditional security and defense concerns and intervene against transactions involving, say a tech company or an energy company. I think it's worth mentioning here that Norway has a general election coming up in about 3 weeks' time, and the likely outcome is that the current coalition, which is a center-right coalition, will be replaced by a central-left coalition. And the parties in this new coalition, they very strongly criticize the current government for being really incompetent and failing to appreciate the national security concerns in the Bergen Engines case. So this could be speculation, but it's conceivable that a new government could wish to demonstrate that they're ready to act decisively if a foreign takeover is getting negative publicity in Norway. So we'll have to wait and see. The current government has said that they're working on updates to the current regime. So the final proposals will probably be prepared and submitted by this new center-left coalition. It will be interesting to see what they come up with. So, but that's the future. So how to deal with FDI screening in Norway today? Let's move on to the last slide. So if you're on the investor side, the first step in Norway is really to confirm whether the transaction triggers any mandatory filings. So you will always need to look not only at the direct target, but also at any subsidiaries in other jurisdictions. That applies to Norway, that applies to FDI screening analysis for any jurisdiction. So if the target is located in Norway or if it has any subsidiaries in Norway, the first question is, of course, whether such target or subsidiary has been made subject to the act by way of an individual decision. And since there's no list, you'll have to ask the target. So that's the first point. And assuming that there's no mandatory filing, the question is, of course, could the transaction potentially give rise to any national security concerns? This is a very concrete assessment and very specific to the target and also to the buyer side risk. I mean, a German buyer is very different from a Russian buyer or from a Chinese buyer. But as a very minimum, any foreign buyer, I think, should ask the target to confirm whether it's making any products which are subject to export control rules, and also whether they're a supplier to Norway's armed forces. Those are the very minimum items. Of course, there could be FDI concerns in other areas. So generally speaking, it's probably fair to say that any sector involving critical infrastructure in some form, such as energy supply, energy transmission, etc., or critical technology, such as IT security, could potentially be considered as sensitive. So that's the case-by-case assessment needed in all cases not covered by Norway's very narrow mandatory filing rules. I think I'll end here with the Norway presentation.
Thank you, Simon, for that excellent presentation. And you know, in a world, you know, still jury still out and early days, as mentioned, and very few precedent. It's good to see that you could enlighten us a little bit about actual cases being, you know, being addressed. So it gives a good, you know, indication on much, you know, which way some of the governments are, such as yourself, are looking at the factors and what's, you know, what are the elements going into the decisions. We will be making sure that going back to you later on, Simon. Thanks again. And going to you, Heikki, maybe you could tell us a little bit about, you know, please introduce yourself and elaborate on the Finnish side of it all, and how it, maybe some of the other countries have looked upon you guys.
Thank you, Sam. I'm Heikki Viide, partner at Magnusson Helsinki office in the corporate and M&A group. I will try to be very brief because we don't have that much time, so we can move on to the slides. The applicable act is originally from 2012, and the latest significant amendments came into force in October 2020. And the Ministry of Economy and Employment is the responsible authority in Finland. And in accordance with the EU regulation, this screening is concerning foreign nationals and legal entities that are not established within the EU or EFTA member states. What I would mention about Switzerland is that Switzerland is part of the EFTA, but it's not part of the EEA. So if you are only buying a real estate asset, then the Swiss acquisitions will fall under the need to apply for the permit, whereas in these corporate transactions, Switzerland is the Swiss acquisitions are not falling under the screening. We can move to the next slide, and I will discuss briefly about the background of this. This says proposed new rules, but these are actually now already in force, and the background is obviously changes in international security and diversity of security threats nowadays. And whereas earlier this was very much concentrated in the traditional defense industry, the definition of defense industry is nowadays wider, and it covers software, cyberspace applications, cloud services, maintenance of defense-related infrastructure, protective materials, and so forth. So the scope of application is now really wider, and also dual-use products have been specifically included now, and also what is a very wide group of products and services that fall under the regime is any services and products which are necessary for Finnish authorities. And you will understand that this can mean virtually anything that the authorities are using, of course, depending on how critical these products or services are, and how difficult or easy it is to get them elsewhere, or how big a threat it would be if such product or service could be in the hands of some unfriendly country or legal entity. Also, the pandemic was definitely a wake-up call in Finland. We realized that the global markets and supply chains can be severely disrupted, and definitely this has an effect on evaluating the deals, which are evaluated obviously case-by-case basis and on the basis of the then current situation. And we can now see that the government is more closely looking into acquisitions that relate to, for instance, production of personal protective equipment and things that are critical and necessary in pandemic situations. So we can say that we have already seen that last year the screening intensified in Finland. Then let's move to the next slide, please. And what the law is trying to protect is the vital functions to society. So traditionally we have been looking at critical infrastructure, but I think that also interpretation of what is vital has the scope has increased now. And as I mentioned regarding national security, this is now also including other things than traditional defense threats. The government is also looking at foreign intelligence and economic influence. So it's a much more kind of diverse also, a new thing that was introduced was a possibility to protect Finnish national foreign and security policy objectives. It's a quite vague thing, and I don't know how often that would be applied outside of the defense industry, but this is anyway included. One thing that could fall under this one is that if the government thinks that this acquisition could be used to lead into a situation where technology could be illegally transferred from Finland, some technology which is subject to export control of certain technology. So that is a reason why the government might choose to block some technology intense acquisitions. It's notable that before the last amendment in 2020, about 80% of the cases which were handled by the ministry under this screening regime concerned more or less traditional defense industry companies. But I think this will change significantly under the new regime. We don't have statistics yet. I don't know, but I really think that it will change. The ownership thresholds that are being monitored is 1/10, 1/3, and half. But it's good to note that the ministry can decide to scrutinize also any other acquisitions, regardless of how many percent is being acquired. We can then move on to the screening process, and it's good to know that there's two kind of filings. You have the mandatory filing for acquisitions that are targeting directly defense industry, critical goods or services to Finnish authorities, and if you fail to file the notification in these situations, the ministry can demand that you file, and you might be subject to criminal charges and fines if you don't comply with this. Then there is also voluntary filing in the other cases that are in principle covered by the Act, and in those situations, companies usually file, parties usually file the notification to be sure that the deal can go through, and the ministry can also, at its own initiative, intervene and demand that an application will be made. The ministry can even grant a conditional clearance that they will approve the transaction if you carve out certain sensitive parts of the transaction. And it's also possible to get a formal decision that the transaction will not be blocked, which is sometimes might be of interest to the parties to get the certainty, even if they think that this is not going to be blocked, but they can anyway get this decision, and they can even appeal from the decision if they want. Regarding the process, one practical interesting is how long it takes, and there is no time regulated in the law, but this is typically something between 6 weeks, 2 months time normally. I think to save time, we don't have to go through everything. Let's go to the next slide. There are certain rules what happens if the approval is denied, but this is not a very typical situation. So let's just skip this one and go to the next slide. And like I said, the assessment of this national interest is very time dependent and case specific, and the law is very open. It does not specify the industries which are subject to monitoring, so it gives a very wide consideration for the government. And what is also interesting that when these latest amendments were introduced, the government estimated that the new amendments will not have a significant impact on businesses. But I think that this is an understatement, and and it's even possible that the lawmaker wanted to avoid the need to analyze those impacts too deeply, because I think that the scope has increased so much that this will definitely result into larger number of filings annually, and it makes much larger number of deals potentially subject to government interference. And it would be interesting to hear from the investor point of view, from for instance, Tuomas or Martin, what do you think? But I think this really causes some uncertainty in deal making. If you have a company which is potentially falls under the Screening Act, you will certainly think of with who you want to negotiate the transactions, and if you are an investor, it might even have an effect on the valuations, because if I was an investor, I might fear that the big buyers from the US or China or Russia might fall out of the prospective buyers, and this could lead to limiting the number of potential buyers and exit scenarios. So I think it does have an impact. Yes, there were a couple of questions from the audience that I picked up from the chat. There was one question regarding that does the law restrict exchange of information between member states and the Commission? According to Finnish law, the ministry can share confidential information in connection of screening only when it's necessary for making the decision whether to allow or deny the transaction, but otherwise they cannot share this information even with other authorities. So it is quite restricted. And another question that I picked up from the chat was if it matters from which country the bio is coming from, that is this really targeted towards, for instance, Russian and Chinese buyers? Does it affect buyers from other countries? Of course it does, but I think the risk assessment is different depending on from which country the buyer is coming from. So I think it does make a difference.
Heikki, thank you. Let's save the questions answering to the Q&A session afterwards. Otherwise, I'm afraid we'll be surpassing the time limit scheduled for this, and we want everybody to stay on board. So thank you, Heikki. Excellent presentation. And Martin, I want you to bring you and Thomas in just quickly before going to Magnus and Magnus and Nikolai. Just a quick question, Martin. You heard some of the presentations so far. Do you envisage this is gonna change any your deal structures specifically going forward, split signing and closing? And do you think that's going to have a major impact on your deal structures going forward?
Yeah, I mean, I think the structures will be more or less the same. But I guess like the burden of documentation and admin will just increase. I guess the reason why it will probably be the same is because it was quite a long time ago we were able to do a simultaneous signing closing. I mean, there's just so much other things we need to deal with as well. So I mean, yeah, we haven't at Summa we haven't done a single signing closing simultaneously. I mean, just our drawdown of funds take 2 weeks. So unfortunately we're already there, but I think Heikki makes a great point. It's a great presentation, and I think it's a great point more on the buyer universe. I think especially in relation to China and Russia, but I mean, I guess China is a bit more significant when it comes to actually acquiring large companies. This is still quite new and rapidly developing, but I guess that there we could really see a challenge, because there are some significant buyers from China, and I guess you would end up in a situation where time between signing and closing is extended with like a couple of months just because you go with a Chinese buyer. That may be problematic, at least from our perspective. It depends, but from our perspective, that level of uncertainty in the process would be quite challenging, to be honest.
Okay, thank you. Thomas, I'm going to bring you in a little bit later again. I'm just moving to Magnus. Magnus, could you, there is a, I'm sure there's a precedent in terms of tender, public tender, it was in Sweden, but maybe could you introduce yourself in terms of Sweden and the whole, the Swedish layout in terms of FDI regime?
Yes, of course. Thank you very much, Sam. Are you able to hear me okay?
Yes, loud and clear, thanks.
That's good, that's good. Very interesting to hear of our neighboring countries, of course. My name is Magnus, and I'm an associate at Magnusson in Stockholm, Sweden. And I will continue with a high-level presentation of the current landscape of the FDI in Sweden. So next slide, please. Yeah, so these were the headlines on newspapers with international reach about 4 years ago. The political fallout from a massive breach of confidential information, including the possible disclosure of information sensitive to national security. The Swedish Transport Agency entered into an outsourcing agreement with IBM Sweden in 2015 worth nearly $100 million to manage vehicle registration and driver's license database. Although this was a matter of outsourcing and the topic for today is foreign direct investments, the current mandates to the legislation in Sweden is applicable in both situations. Unlike other cases involving breaches of government data, the case in Sweden does not appear to involve hacking or other malice. Instead, the focus has been an apparent absence of proper safeguards and oversight. The soon-to-be former Prime Minister of Sweden called the breach of information a total breakdown. And one of the points raised following this data breach was to give the relevant authorities the proper means to manage in situations going forward. So the next slide, please. So this brings us to the regulatory framework in Sweden as of today. In the wake of the pandemic, there were concerns that foreign buyers would take the opportunity to make hostile acquisitions, but that has not yet occurred in Sweden to any large extent. However, Sweden has two major initiatives regarding FDI screening. The first is an amendment to the Protective Security Act, entered into force the 1st of January earlier this year. And the second is a parliamentary inquiry which was appointed to investigate and propose legislation introducing a comprehensive FDI screening procedure and blocking mandates. And this inquiry is set to deliver the proposal in November later this year. Moving on to a bit more detail regarding the first initiative. This is a fast-tracked initiative expedited by the COVID-19 outbreak and was, as I mentioned, implemented the 1st of January by means of, sorry, can you move to the next slide, please? Thank you. And so this is the first amendment, and according to these amendments, seller of assets or shares in a company that engages in activities covered by the Act is obligated to consult with the competent authority. And the Act covers, as shown in the slide, whoever is engaged in activities of importance to Sweden's security and who is otherwise covered by a legally binding international commitment by Sweden regarding protective security. We gathered, and the takeaway from this is the provisions are not sector specific and the applicability depends on the operations of the transferred business. There is no exhaustive list, but some of the industries are listed in the slide, such as civil infrastructure of healthcare, airports, power plants, information system, financial service, and food supply. And moving on. The criteria, sorry. the criteria for the review means an introduction of a control mechanism in case of transfers of security sensitive activities and operations. And this means a pre-authorization requirement before an acquisition can be completed. And the amendments hold that you need to conduct and document a security assessment, a suitability assessment, and after that consult with the Swedish Security Service or the Swedish Armed Forces. This may include disclosing ownership structure or the foreign investor that the company in which the foreign direct investment is planned to be completed. This may include the approximate value of the investment, which products and services are sold, and the source of the financing. Following the consultation process and the criteria for review listed in the, yes, thank you. Following the consultation process, the competent authority may decide to either allow the investment, impose conditions that need to be met for the investment or transaction to be allowed, or block the investment. And if businesses, property, or shares are transferred in violation of the Act, the competent authority might prohibit the transaction, and the transfer will automatically be considered null and void, and that means not legally binding. The amendments do, however, not contain any rules on penalties for failure to comply with the requirements. However, if a transaction is deemed null and void, it is suggested that the responsible authority will have a right to order both the seller and the buyer to take any measures necessary under the penalty of a fine. And moving on, the second initiative is, as I mentioned earlier, a parliamentary inquiry that has been appointed to investigate and propose legislation introducing a comprehensive FDI screening procedure and blocking mandate. And this inquiry is set to be delivered later this year. At the picture on the far right, this was the headline from yesterday's newspaper, in which the Social Democrats, the leading political party in Sweden, wanted to make further inquiries regarding the ownership structure of a foreign investor named Tencent, a Chinese tech and AI conglomerate. This Swedish Home Secretary was, when pressed about the situation and the legal grounds, referred to the second initiative rather than the amended legislation. And we find this interesting to refer to an ongoing investigation, and it makes it doubtful to the applicability of the amendments currently in place. Why purely theoretical, we see no problem that they would be applied in this situation, since it's a very broad scope. We've tried in preparation for this presentation to get more information, but it's difficult to obtain. If even at all this First Amendment has been applied in other instances. Hopefully we can maybe tell you a bit more about this in a following presentation, but there is obvious political pressure concerning the second initiative, which is proposed or set to be proposed later this year. On to the last slide. Just some closing remarks. Our comments are a lot following my Finnish colleague, and the legislator has intentionally kept the scope of the regulation flexible. Assessments of the threat to critical national interest is always time dependent and case specific, as Heikki mentioned as well, which does not correspond well with the suggested amendments contain no set time limit for the consultation process. But we will, of course, continue to monitor this with great interest, and who knows, maybe a follow-up seminar once the proposal has been presented. Thank you.
Thank you, Magnus. That sounds like a good idea. Thank you very much. We're coming back to you with some questions actually regarding Sweden. Without further ado, our last presenter is my co-partner and leading FDI expert, if I may say so, in Denmark, Nikolaj Juel Hansen. Please, the floor is yours.
Thank you, Sam. Well, listening to all of you guys, I can certainly say that the Danish FDI regime that comes into play in a week, applying to all transactions closing from 1st of September, is an FDI regime on steroids. Please flip the page. Denmark has wanted to introduce what they call a very robust screening system in the more restrictive end of what is seen in the EU. Please flip slide. It is, as elsewhere, a dynamic piece of legislation that allows additional sectors, technologies, and infrastructure components to be added at a later stage. Next slide. I've heard someone call the Danish system trolling where fly fishing is required. I think you'll understand why when I just flip through the slides here. We'll have the next slide. As I said, it applies to all transactions completing from 1st of September. So if anyone is out there trying to close a Danish deal, now is definitely the time to do it. There is absolutely no thing in Denmark that says that this will change, because it was voted through with broad political backing. Again, on the next slide, Denmark is obviously trying to protect national security, public order. I think what becomes very apparent from this presentation is that it is different regimes in every country. We're seeing the rules mushrooming up, and especially on cross-border transactions, this will be somewhat of a complex regulatory issue. I've mentioned here some of the issues that Denmark views as national security and public order. Under the Danish rules, please, the next slide, we have a very broad definition of foreigners. So it is basically any foreign person and almost all foreign legal entities. The Danish rules does apply to EU countries. So a Swedish company buying a Danish company is comprised by the rules. Even a Danish company with a Swedish shareholder that has 25% or otherwise can exercise control, a bit similar to the universal business owner test with 25% or decision or veto rights or director appointment rights, will be deemed to be a foreigner under the Danish rules. One of the only companies or entities that are actually excluded is the Norwegian oil fund. However, only if it operates directly, not if it operates through a subsidiary. So we have basically an all-inclusive menu for foreigners that even extends to the EU and Danish companies where there is control by a foreigner. In terms of the critical sectors on the next slide, these are again very broadly defined. There is no lower limit, meaning that if you are a company that has 1% of your revenue in a critical sector, you are a critical sector company. As for infrastructure, and we'll get back to that later, if you are what is called supporting in the Danish legislation critical infrastructure, you are an infrastructure company. If we flip the page, the critical sectors are named in the black boxes: defense, IT security, and dual use products. In the yellow boxes, we have the specific definitions of what is at the moment perceived to be critical technology in Denmark, which is very broad. And in the white boxes, we have the 11 critical infrastructure sectors. And if, for instance, in the Danish rules, you are supporting financial infrastructure, you are a key infrastructure company. If you are supporting IT infrastructure, you are a critical company. So the Danish rules will extend to a large number of transactions going into Denmark. Critical infrastructure turning to the next slide, as I said, if you support it, and it is basically anyone that has direct or indirect ownership of, operational responsibility, even through outsourcing, or public responsibility over facilities, networks, systems, technologies, processes, services, or assets that are necessary to uphold or restore important functions in society. If you turn to the next page, we have now a right or a possibility to ask the Danish government, the Danish Business Authority. We have a US client that is about to sell a Danish subsidiary. That Danish subsidiary has about 20% of its revenue coming from a line of business that it delivers components for offshore foundations for wind farms. That component itself in a wind farm is under 1%, and it is easily substitutable. So that Danish company being sold, we asked the Danish Business Authority whether such a company that had only very little revenue directly from what is perceived a critical sector would be deemed a critical sector company. And the answer was that any company that delivers components to other companies within critical infrastructure would also themselves be appointed critical infrastructure. At least there's a possibility for that, which kind of extends the Danish rules a lot. We have a division in Denmark, next slide, between investment transactions and what is called special economic agreements. The investment transactions are when you acquire control or share ownership or voting interest, 10, 20, 1/3, 50, 2/3, or 100. And if you go first from 0 to 15, and then subsequently from 15 to 25, you need to make 2 applications. There are no lower thresholds in Denmark, meaning that any transaction basically is under the scope of the control. The percentage calculations include shares that are directly or indirectly controlled under the IAS 24 scheme. And there are some specific computation rules about these thresholds. If you flip the page, in Denmark, of course, if you acquire shares, that's easy, but it's also control over or access to voting rights. It's joint control, for instance, through shareholders agreements. You are counting potential voting rights with warrants or options that are eligible for exercise. You have control, even if you don't have 10%, you have control if you can take veto or approve decisions on material issues, or if you have a right to remove members of the executive management. The Danish rules notably have extraterritorial effect. So if a Swedish company sells a division with a Danish company embedded inside of it, and control over the Danish company thereby shifts, even if indirectly further up in the chain, that transaction is subject to the Danish rules. And as we have a gun jumping prohibition, the entire international transaction will become subject to approval in Denmark. We also in Denmark include greenfield investment, meaning that any company establishing from now on a subsidiary in Denmark falling within critical technologies, critical infrastructure, or the critical sectors will need to have that establishment approved. You can also acquire control, for instance, via long-term loan agreements or leasing, and you can also acquire control via asset deals. The Danish rules also apply to control over listed companies. So a very, very broad range of transactions with a very few exceptions. Next slide. There are some intra-group reorganization exceptions. There is a startup exception where investors can inject up to 10 million euro during a 3-year period if the Danish company does not, through that operation, become a subsidiary. And there are exercise of, or basically enforcement of pledge transactions. If you then turn to the next slide, Denmark has included what they call special economic agreements. Here we are only after, so to speak, non-EU entities, but only again true non-EU or true EU non-EU equities. So if a Danish company that is fully controlled or a EU company that is fully controlled are not subject to these rules, but for instance, a Swedish company that are in turn owned or controlled by an American company or a UK company will have these rules. the special economic agreements are a lot of R&D joint ventures, many supply agreements, and thereby very relevant not only for direct investments but also on day-to-day operative agreements for Danish companies. If you are entering into a supply agreement with a foreign company, that might from now on, from a week's time, fall under the FDI rules. Those are agreements that are very often made by general counsel or legal counsel sitting at their desks without involving anyone. So you really have to pay attention to whether you are operating within the designated sectors in Denmark. It also relates to operational and service outsourcing agreements. Flipping the side, we have other tracks. There is a general track of a voluntary, and we have the ability to request a pre-screening, which should imply more deal certainty than just rushing into it. As I said, flipping to the next slide, Denmark has a gun jumping prohibition. There is a 60-day review period, but that can be extended if there are lack of information or if we have delays. There was a question about staffing. We feel in Denmark that the staffing is not adequate and that we might see long waiting times when the system kicks in a week's time. There are a lot of application formalities, flipping to the next slide, but it's all digital. It can be in English. If we do it as lawyers, we have to document that we are allowed to do it. And then there are some formalities here which I don't want to go into further. Flip through the next slide and go on to remedies. If you proceed without authority, the Danish Business Authority may revoke voting rights. They can expropriate assets, and special economic agreements are null and void, as we heard from Sweden. There are no penal consequences for the Danish for sort of overstepping the Danish rules. In Denmark, you have a system for challenging a negative ruling by the Business Authority. Flipping to the next slide, must be lodged within 6 months from the ruling. And it is a very special system because we are concerned with national security and public order. The court will appoint a specific counsel, a special attorney for you, who will act on behalf of the foreign party, but may not share information with the applicant because it's not allowed since it is national security and public order. And there are a lot of limitations on access to information. So Denmark has introduced, and it will kick in a week's time, a very comprehensive rule set that will, in our view, limit transactions, also operative transactions with foreign parties a lot. And Denmark goes, in my view, from a very open economy. And Janus, maybe on your index, we will see Denmark in another place in the 2021 review, because I think we are actually going into an area where there will be a lot of restrictions on investments into Danish companies and on Danish companies' ability to interact with foreign suppliers, distributors, and joint venture parties.
Thank you, Nikolai, for that excellent presentation on the Danish side of it all. Moving to a couple of questions, I want to bring you in, Thomas, and thank you for your, being patient and waiting for the presentations. Just a question out to you, and actually most of the panel. What is your view on the big picture here? Do you think how much do you think is going to hurt the investments in the Nordics? I mean, building these walls. Do you see that as walls, and do you think this is going to impact the business, inbound business going into the Nordics and Baltics? Could you just drop a couple of lines there, Thomas, and maybe Nikolai, you could elaborate?
Yeah, absolutely, happy to. So I think that the big picture is that there is obviously we are seeing this kind of like a globalized world a little bit closing in. Even in the Nordic countries, which has been maybe the most liberal and most open economies on the planet. I think that if you listen to the leading politicians, there's still a strong desire to keep the Nordic markets Nordic countries open for business. The Danish approach is obviously, I would say, quite extreme compared to what is happening in some of the other countries. It's a very good question, and I think these are those items where you really need to find the balance. I think it makes sense to have some kind of like screenings in place, and there are concerns, so then the legislatures must take some actions on it. But then I think the really key questions are like on what are we trying to protect here, and then again, like what do we need from the overseas investments if we want to sort of really reduce foreign investments, for example, on R&D and stuff like this, then what is the impact on that? And I think it would be very interesting to follow the Danish approach and see if there is some real impact, because this is completely different from what's happening in Finland and Sweden, for example, which are, of course, also big recipients of foreign R&D investments.
Thank you, Thomas. Nikolai, maybe you have a follow-up comment.
Yeah, I think it's true. You know, one of the slides showed that foreign direct investment in the period from 13 to 18 took care of 30% of the Danish GDP. So it's massive numbers we're talking about. And my view is that Denmark has gone in, you know, way too high, and it will impact transactions. I think that you know, looking at this and comparing it as Martin, you did at a certain point in time, to sort of the merger control rules. There we have a system that kind of is the same in each of the countries. You know, we measure the same. Is there, you know, is this, you know, activity comparable? Here we're talking about regimes that, in my view, will continue to pop up or mushroom up in different shapes and sizes in each country, because of the fact that we're talking about national security and public order, and the EU will not be able to kind of regulate, you know, how the countries should act on this. So in my view, we are in the EU creating a very complex regulatory regime, because we are basically having so many different regimes that a cross-border transaction will pitch into. So that's the sort of the global picture. The Danish picture, in my view, is that the Danish Business Authority should have employed, you know, 50 or 100 people rather than 10 when the Danish politicians have gone in as they did. And I really think that we've created a big problem for ourselves. Come 7 days in terms of being fully agree with Thomas that, you know, we used to be a very open economy. Now we're not. The fact that a foreigner has to get approval to establish a subsidiary within a critical sector without even having employed anyone or basically entered into any agreements with anyone is, in my view, a tough regime to run if you want to attract foreigners and their money to develop Denmark. And I think from listening to the conversation, you can see how different the rules are, even in these 7 countries that are sort of normally quite comparable.
Thank you, Nikolai. We have a couple of questions that we need to address. I know that Janos and Nikolai have been addressing some of them during the chat room, but going over to you, Simon, just a question from Christian Berger. If the transaction triggers no filing requirement in Norway, how can the parties of the transaction achieve legal certainty that the transaction can be closed and is not dissolved by the government? Can the Norwegian government also impose conditions and remedies after the transaction is closed? And there's a statement saying, finally, in Germany, it is possible to apply for a certificate of non-objection. Could you enlighten us? Could you respond to that question kindly, Simon?
Yeah, I mean, this really puts the finger on the problem, I think. So, short answer, you can't get legal certainty. You can get a sufficient degree of comfort. You can approach the authorities informally, provide details on the transaction and on the buyer, but there is no formal system for voluntary notifications, unlike in typically merger control regimes. So you only have to trust that this was sufficient to proceed on this basis, which I think is not good. And second part, can they come after 5 years and 10 years and say that the transaction has to be unwound? In theory, yes. So there's no limitation in time on that power, which is not a very helpful way to frame a review clause, I believe.
Thank you, Simon. A question for you, Heikki. There's a question from Mr. Christian K. Any thoughts on deal size implication? Will it affect small and/or medium-sized deals? Will the holdings of the buyer be taken into consideration in the screening, i.e., owning multiple small critical companies, versus a few large critical companies? Could you comment on that, Heikki, please?
Sure. As far as the paragraph of the law is concerned, it doesn't address any of these issues specifically, but the first question about the deal size, I think this can apply more or less equally to transactions of any size, because we know that in today's world, even small companies can produce quite critical things. So I can't really say that the deal size would, in my opinion, necessarily guide the screening too much. And this will apply also to small and medium-sized deals. We had a telecom deal last year, which was, well, medium-sized, but extremely carefully scrutinized by the government, and the buyer was Chinese, and they got the approval at the end of the day after 7 weeks of consideration. And then will the holdings of the buyer be taken into consideration in the screening, owning multiple small critical companies versus few large critical companies? I think it's not only screening of the target of the acquisition, but I think they will also consider who is buying from what country and what other business they have. So I think it can play some kind of role as to what kind of holdings the buyer already has in some other businesses. Yes, I think it is relevant. Also, obviously, when you make one transaction, you don't know what else the same buyer is going to buy next week or next month or next year. So that's also a tricky thing for the authorities to consider, because they don't know what the future is going to bring. But I think they will consider at least the current situation regarding the buyer.
I think you're right. I mean, this is one of the going through all the countries. I mean, and in Denmark, this is one of the cases where size actually doesn't matter. They will be looking at case-by-case basis, particularly because there is not much precedent to. We had Norway, Simon, elaborating on that case in Norway. But other than that, there's a very much limited precedent. So uncharted territories, I would say, so far, even for the authorities, when you speak to them here in Denmark as well. So they need to, they are facing uncharted territories here as well. Moving, to you, Janos. There has been some questions in the chat room, and you have answered some of them. And do you think you answered that? That insight into staffing of the regulators. Are they going to have the resources to keep up with this? And you answered that as well. And that's one of our main concerns here in Denmark. Will there be enough hands to address these deals as of September 1st? And Nicola touched base on that as well. So Janos, what do you think? And how do you see it in the Baltics?
I'm sure that any new regime will have to have also new dedicated resources to it. And I'm a little bit concerned about the planned structure of the Estonian regime, which is not even a permanent body. It is more like a inter-institutions commission. So I'm not sure if the scope is very small and they really have to vet 2 deals a year, that's fine. But if the scope is wider and more transactions will be scrutinized, then of course there must be more resources.
Thank you, Janos. Magnus, there's a question in the Q&A box. I mean, in what power does a determination that a deal falls under FDI law give a regulator in Sweden? I know you have addressed that already, but maybe you can answer that live as well.
Yes, of course. So now we're into the review outcomes after and the actual enforcement, and the most extreme enforcement is of course to declare the deal null and void, that is not legally binding, and this is of course under proportionality depending on what the deal is concerned, because the current legislation is has a very broad scope beyond direct investments as well.
Thank you. I just want to, in the interest of time and getting there closely, it's 5:30. Just a quick question to you, Thomas and Martin. I mean, do you envisage a lot of lobbyism going on forward? Do you think there's going to be a lot of lobbies in terms of this FDI regime, the screening process? And Nikolai, maybe you can, after Thomas and Martin, touch base on the politicians and the political side of it all. We had some well-known cases in Denmark that you can mention afterwards, where the politicians actually made the deal go through. So having said that, Martin and Thomas, do you envisage a lot of lobbyism, and how do you see it? Thomas and then Martin?
Yeah, sure. So I think obviously there will be quite a bit of special interest looking into these cases, especially if you are talking about some big investments or big projects and big deals. And so definitely, yes, I expect to see quite a bit of all kind of lobbying, and certainly I think it's fair to say that there has been also all sorts of lobbying from different sides, and it's not always only the private companies who are doing the lobbying, but there might be some government authorities, for example, who have their own sort of a lobby organization to push through their agendas in the security space, for example, and they also do lobbying. So certainly, yes.
Martin,
Yeah.
in terms of private equity investors, and you guys have a lot of muscle. There's dry powder out there, and how do you see it?
Yeah, sure, but I mean, we typically avoid spending the dry powder on lobbying, though. I guess that would probably trigger some LP unrest. But no, I mean, definitely this is a thing. I guess that, it's a coordination matter in some respect. And I think from our perspective, it's primarily handled by Invest Europe. So we try to come together, and there, I guess the main focus is actually just finding clarity and having sort of a level playing field. This is happening, right? So it's more kind of just realizing that fact and kind of avoid ending up like the Danish situation, to be honest. I mean, I think that sounds like a nightmare. It's going to be super interesting to see how it plays out in practice. I think that, just avoiding that situation, finding some clarity, that's kind of, and there's actually a lot of lobbying going on, and Invest Europe is quite vocal on commenting on different regulation propositions, and also trying to, we do what we can. I mean, from our perspective, it would be much better if this was at least somewhat harmonized. I mean, yeah, I guess that's kind of the key items, to be honest, from our perspective.
Excellent.
I think in Denmark, evil tongues will say that the Danish Law Society lobbied for the extraterritorial effect to give Danish law firms more revenue when we have to approve all the global deals. I think that comes back to the trolling where fly fishing is required commentary in Denmark, because we've had a lot of deals mentioned, in the political discussions about all of this. And interestingly, the rules are so strict because of transactions that are not captured by this, or especially components of those transactions. So we have a lot of political debate about Goldman Sachs' investment in Ørsted, the Dong, but that was driven through by the politicians. Similarly about Macquarie into Copenhagen Airport, but again, a politician-led deal. And both of those criticized heavily for tax haven issues, which are not at all FDI related, but the rules have been stricter for that. We've had a lot of discussions about the sale of the state vaccine facility to a Saudi buyer 4 years ago, and obviously that comes up heavily during COVID-19 times, but again, a politician-led transaction. In my view, we have in Denmark, disbanded motorways because some people are driving 115 there, and that's never clever in my view. And I think it's basically the Danish political systems who went scared and wanted to, make a defense for any kind of arguments about foreign deals gone sour in the future. And I think they've really made a mess out of it. That will be time consuming, it will be complex, and there will be so many questions to the Danish Business Authority about these that it seems like we'll develop fairly quickly some legal precedent here, because there will be so many cases. Denmark says that it will not restrict it. There's no intention of restricting foreign investment, so I don't think we will see a lot of rejections, but there will certainly be a lot of cases submitted for screening approval, and just the timing of that might discourage buyers from going in. So comment from Denmark on the political development.
I'm optimist of nature, and I think politicians are in the game of getting votes and re-elected and getting elected. In my book, in my humble opinion, I think at the end of the day, foreign investments will create jobs and a better economy. And I don't think there's a politician that wants to go against that stream. Otherwise it'd be a short life as a politician, a political career. But having said that, I think judging by everything, you guys, a sincere thanks, heartfelt thanks to all of you. To all the participants, the attendees, thank you for taking your time out of your busy schedules. Thank you to you, Martin, for keeping up with us and tolerating the lawyers on this panel, and including myself first and foremost. And thank you, Thomas. Thank you to you both for adding that extra flavor which was necessary in terms of business perspective. Thank you to Simon from Hoven Visli, our close friends from Norway. Thank you, and very interesting president and the whole regime in Norway. Thank you for being part of this panel. And sincere thanks to all my fellow esteemed colleagues throughout Magnus and Nordics and the Baltics, Heikki, Magnus, Janus, and last but not least, my co-partner friend Nikolai. Thank you, everyone, and obviously you're more than welcome to reach out to all of us. You have the contact details, and reach out anywhere you want, and on LinkedIn and on our website. We'd be happy to answer any follow-up questions you guys might have. And the jury's still out, still early days, and let's hope and cross fingers that investments keep coming in, not only to the Nordic and the Baltics, but across Europe. And let's look forward and be optimistic in our views going forward. And thank you, guys. Thank you. Anybody who has any final comments, please let me know. Otherwise, I will turn to James and Ben to have the final word.
doesn't look like it. So look, sorry, it's probably weird for me to just appear out of nowhere, but I'll just thank you all from Legal 500's perspective. Thank you to lawyers at Magnuson. Really interesting to hear your thoughts, really positive feedback from the audience. Thanks, of course, to Martin and Thomas. Really appreciate it. And yeah, that's all from us. But look, thank you. The video will be going up online. So anyone who wants to relive it or to get the contact details of the Magnuson partners, please watch it on Legal 500's website. Okay, thank you very much.